Hello, everyone. Good afternoon. I am Nuhad Ponce Kuri. I am honored to be here with you. I am the president of the Advisory Council of the National Institute of Transparency, Access to Information and Personal Data Protection, the INAI. I am very glad to be here with you in this Global Privacy Assembly 2021. And I am going to present our parallel session about digital rights, fostering human rights through technology. This is a very interesting topic, and I think we are going to have a great time here these 2 hours. We're going to interact each other with our panelists, and we are going to be talking about these essential digital rights in the internet. I would like previously introducing all the panelists, just to let you know, like a few little introduction about why law needs to be adapted to protect and safeguard our fundamental rights. Of course, digital rights are closely linked to these to our freedom, to our expression, to our privacy. And it is very important to have a clear legislative framework in order to have prevention about violating our rights. Also, ethics it's very important topic that we are going to talk about this ethic regulation, obviously in artificial intelligence, and these cyber rights that could be recognized in the right of individuals to access, use, create, publish, translate digital media. What are those digital rights? Are they human rights in the internet era, or they are just new rights, or they are rights that are going to be adapted in this new train of technology, let me call it that way. So we're going also to talk about biometrics, geolocalization, what are United Nations talking about this Universal Declaration, right? We're going also to know what can we do and how do we know if our digital rights are being respected. Who is looking to my data? How can governments use this information, this personal information and data? And it's important also to have the view of different parts of the world. I mean, I'm very glad to introduce these very experts in this topic. I'm going to present first of all, and if you can appear in the session, please, and I am very glad to introduce Katitza Rodriguez. She is the Director of Privacy Global of Electronic Frontier Foundation. Gus Hosein, he is the Executive Director of Privacy International. Rafael Yuste, he is Professor of Columbia University. And also we have Lorena Naranjo, she's Legal Director at Denton Paz Horowitz at Ecuador. Hello everyone, I'm very glad to have you here to make this international panel with a really interesting topic about what are going on with our digital rights, all of these cyberspace regulation, how is ethics involved in all our day-to-day protection of digital rights. And first of all, I would like, as we're going to make this panel very interactive and very practical, I would like first, if you agree on this, to have an opening statement of each and every one of you, around 5 to 7 minutes, just to know the initial position of all of these treatment, digital rights, and the introduction I've just made. So if you're okay on this, we can start with Lorena Naranjo. Lorena, how are you? What can you tell us about this?
Muchísimas gracias.
Thank you so much. It's a pleasure to be here. For me, it is important to highlight the need to protect digital rights should be understood by everyone. It means that citizens are the main beneficiaries, and this is a challenge because a culture of data protection is a big responsibility of the state. But there have to be people who actually take on the responsible role for disseminating the knowledge and the training, and so that they can approach the topic not only from the point of view of compliance, but the roles that people must take on as disseminators of these follow ups. The process for generating responsibilities among officials, particularly because the responsibilities are those that allow the management of compliance. If each one of us knows what we have to do with the personal data in our specific work roles, then we are all contributing in the long term to a society which protects data from a comprehensive viewpoint.
Thank you very much. Jane, how are you? Nice to meet you. And please, if you can tell us about your opinion about these digital rights in this technological era. Sorry, Gus, we are not in, I don't know if you're here with us just to help us, please. Gus, can you hear us? Excellent. Thank you, Gus. Perfect. Think you can go ahead. We can see if the technical problem is solved. No, we can't hear you, Gus. Daniel, if you can, Daniel, si nos puedes, por favor, ayudar a Gus. If it's okay for you, while we are solving the problems with Gus, perfect. So, Katitza, can we go with you if you're okay? Perfect.
Correcto.
Yes, los derechos digitales son derechos humanos, pero
Disculpe, ahí escucho la traducción de lo que digo. ¿Cómo, cómo puedo? Cuando hablo, escucho la traductora también. Okay. Um, Thank you for the very kind invitation. I can believe it has been 10 years since we last met in Mexico. Time flies. I would have liked to be together in person and share some of the many Mexican delights, including San Mole Negro or San Mezcal. but very happy that we were able to gather online. Today, I want to talk about a concerning trend in multilateral agreements that seek to erode national legal safeguards in the name of facilitating law enforcement access to data across borders. Data protection authorities from around the world have a particularly important role to play by getting engaged in these discussions or ensuring that they participate in the national debate when such agreements are being discussed. So, what is happening in these multilateral agreements and how it's affecting our human rights or digital rights? Law enforcement cross border investigations raise difficult questions as many different legal systems clash. How do data protection law regulate the police collection of and use of our personal data when the collection processes span multiple countries and legal systems? Governments have been ramping up the pressure to streamline the process by which the police in one country can get a hold of personal data abroad when it's relevant to certain investigation. Something that happens more and more frequently in our globalized world. They find that existing treaties like the Mutual Legal Assistance Treaty is too slow and cumbersome and want to put in place new instruments and mechanisms that will let data flow to police more quickly and easily. One important initiative of or rather on this topic is just being adopted by the Council of Europe Cybercrime Committee, not to be confused with the Convention 108 Data Protection Committee. It's another committee. This committee has recently finished negotiating what is called the second additional protocol to the Budapest Convention, an international agreement that deals with rules for police to access data cross border and which is expected to be approved in November. Since the Council of Europe conversation is by far there are many other agreements, but I'm focusing on that today as I think it's relevant for all the data protection authorities who are here and be engaged in this discussion, especially when this multilateral agreement start or is going to be discussed in Congress. So there are many different kinds of international evidence gathering and international law enforcement cooperation that already happens. But the second additional protocol seeks to establish new international standards that will govern several aspects of police at global scale in the future. Many parts of that standards are usually I have been law enforcement wish lists because the committee and the people who negotiate the treaty was largely driven by prosecutors and law enforcement agencies or interests, with minimum input from civil society and independent data protection regulators. It's also hardly surprising that the protocol fails to provide detailed and robust data protection and privacy safeguards for most of its new detailed law enforcement powers. Quite the contrary, the protocol avoids imposing strong standards in an active attempt to entice states who have weaker privacy or weaker human rights standards to sign on. To this end, the protocol recognized many mandatory and intrusive police powers coupled with relatively weak safeguards that are largely optional in nature. The result of this negotiation is a net dilution of privacy and human rights on a global scale. In other words, a trend to harmonize to the lowest common denominator in terms of privacy and other protections. So the protocol has two, is very brief, and today I'm going to focus only on the data protection safeguards. It has two articles, one related to privacy, another related to data protection safeguards, which is Article 14. In this case, Article 14 provides some data protection safeguards that will apply to any transfer of personal data obtained through the protocol's new law enforcement powers, unless the transferring have another agreement in place. However, these Article 14 are weak, and even these weak standards can be circumvented by any two or more signatories by agreement. This is why it's very important that at the moment that the protocol is being discussed in their country, and this will change country by country, DPAs get engaged. Signatories to the protocol are explicitly permitted to bypass these safeguards through various mechanisms, none of which provide any assurance that adequate privacy protections will be in place. So due to lack of time, and I just have 7 minutes, I will just give 3 examples, or 2 examples. Article 14 requires parties to ensure that personal data collected through the protocol's powers be consistent, be relevant to the criminal investigation that prompts the collection. However, contrary to most other data protection instruments, Article 14 data protection safeguards don't require all processing of personal data be adequate, fair, and proportionate to this objective. As we hear Mark Rottenberg in the morning talking about the importance of the first principle, this is a red flag for us. But most importantly, Article 14 safeguards also don't require law enforcement to be subject to oversight that is completely independent and impartial. Article 14 of the explanatory test, which was never subject to public scrutiny, allows oversight bodies to be subject to indirect influence. Under this article, for example, many oversight functions that can be conducted by government officials.
Thank you, Katitza. I think we're having some problems with your audio.
Oh.
It's like an echo.
Oh.
If you want, we can go with Gus in order that you can figure out what's going on with the audio.
You didn't hear me anything because I was just to conclude right now. Did you hear anything?
Okay, we're here with an echo.
Do you hear? Oh, thank you. Okay, just to finish, under Article 14, for example, many of the oversight functions can be conducted by government officials housed in the same agencies. And the article prohibits countries or parties for requiring the use of independent regulators, such as the DPAs, to protect the privacy of personal data when transferred to other parties through the protocol's powers. So I want just to use this opportunity and call upon the Global Privacy Assembly to take up this topic and issue a resolution setting stronger data protection standards in the context of cross-border policing. With detailed law enforcement powers should come detailed privacy and data protection safeguards, not a one-sided law enforcement compromise of privacy and data protection. We hope also that the TPDP Committee on Convention 108 work together with DPAs at the local level to ensure that when the protocol is discussed in Congress, Convention 108 is discussed together and both can be signed at the same time. Thank you.
Thanks to you, Katitza. Gus Hosein, welcome back. Let's see if the audio helps us this time. Don't worry, we'll let Daniel knows that we're here. Daniel, si tú me escuchas, seguimos teniendo problemas con el audio de Gus Hosein. No sé si andas por... In the meantime, we can go with Rafael Yuste, President of Columbia University. Welcome, if you can please make your first statement about human rights.
Hi, can you hear me? I hear an echo, actually. Yeah, there's every time I speak, there is an echo.
Yes, we have an echo. Let me see, what can we do? Probably, right. Daniel, no sé si nos escucha. Gracias. Y sabes qué, no escuchamos a Gus Hosein, seguimos con problemas de audio. Ok, perfecto. Entonces, en lo que pasamos con Rafael, nada más que escuchaba un eco.
Okay.
Thank you. Gracias, Daniel. Thank you, boss. Welcome back.
Can you hear me now?
Yay!
Yay!
Finally.
There's a little bit of an echo, but I'm sure it'll be fine. I now only hope I have something interesting to say. Katitza's presentation already covered so many of the interesting dynamics of what's going on in our field. And I also want to say, like 10 years ago, I was in Mexico for this conference, and I was asked when I was on a panel around big data, because big data was still a new innovation back then. And I was asked if I felt like the law and regulation could help deal with the challenges of big data. And I answered, much to the anger of the regulators in the room, that I didn't think that the regulators that were in the room were capable of dealing with that innovation question, that they were not going to stand up against big data and the massive exploitation of data to the disadvantage of people across the world. And instead, we would have to look to other regulators, such as competition regulators. And in the last 10 years, I think that's been proven right, that with no new legal regime, competition regulators have stood up and said innovation shall not happen. Yet we haven't seen that with data protection regulators, even even where there have been new laws introduced. So the whole idea that law can come in to save us from new threats and new challenges, I can say as an organization that's been around for 25, 30 years, that have been fighting intelligence agencies, fighting the Googles and the Facebooks, the problem hasn't been the law. The problem has been that our institutions that we look to, whether it is the courts or the regulatory authorities, have not been willing to stand up and say they're going to stop something that's on the face of it very problematic, legally and clearly in contravention to what is expected. And so whenever we are approached to comment on, should there be a new convention? Should there be a new set of laws? Should there be a new set of safeguards? I always hesitate because the existing ones aren't enforced. The existing regulators are being undermined. And I'm talking to an audience in Mexico from the United Kingdom, two regulatory regimes where regulators are being undermined. And it's not just those two jurisdictions, of course. And so we're at this critical moment, and we have a poor track record. We have the rule of law being increasingly undermined. So to look for a new regime to solve our problems feels like a distraction.
Thank you. Thank you very much, Gus. Please, Rafael Yuste, if you can please give us your position. Rafael, I don't know if you can hear us. That was why. Ready, Rafael? Can you hear us right now?
See,
Okay.
I can now. Yeah.
Thank you. Please go ahead with your statement. Thank you, Rafael. If you can please give us your first statement about these digital rights, please.
Can you hear me now? And there is no echo, no? Yeah. Yeah. Anyway, my name is Rafael Yuste. I'm an MD PhD and a researcher at Columbia University, and I study how the brain works. We do experiments. I run a laboratory, and we study the cerebral cortex, which is the largest part of the brain in mammals. And I also represent a group of people, a group of 25, which is called the Morningside Group, because we met here in the Morningside campus of Columbia University in 2017. And our group proposed new human rights, which we call neuro rights or brain rights, to be added to the Universal Declaration of Human Rights. Our group is formed by experts that come from academia, from the clinic, from the tech industry, and also representatives of the brain initiatives of the US, Europe, China, Japan, Korea, Australia, Canada, and Israel. And the neural rights that we propose are needed because technology, and in particular neurotechnology, is advancing very quickly and is not at all regulated. And neurotechnology can affect the essence of what it means to be human. Neurotechnology are techniques and methods and tools to record the activity of neurons in the brain or to change the activity of neurons in the brain. And because the brain is not just another organ, but is the organ that generates the human mind, the ability to record the activity of the brain and to change the activity of the brain makes it possible to decode the activity of the mind and to change the activity of the mind. And humans, we define ourselves by our mental abilities, by our minds. So this is the first time in history that technology can have access to our mental processes. Because of this, we think that the brain should be protected with these new human rights. And this is something new because in the past, this technology didn't exist. And people thought it would be science fiction to be able to get into someone's mental and cognitive processes, but this is now possible. So the neural rights that we propose are 5. The first one is the right to our mental privacy, so that the contents of your brain activity cannot be decoded without your consent. This will prevent mind reading and will protect our the privacy of our thoughts and our feelings and our memories, and even the privacy of our subconscious. The second neural right is the right to our own identity, to our own self. And this is necessary because with neurotechnology, you can change the sense of self. And it's not surprising because the self, like all of our mental and cognitive abilities, is generated by the brain. So if you can change the brain, you can change the self. And this is something that happens already in animal experiments and also in some cases of patients that wear neurotechnological devices as therapeutics for Parkinson or severe depression or paralysis due to stroke. Our third human right, neural right, is the right to our own identity, to our own agency. That means to our free will, to our liberty, to protect our decision making so that it is not manipulated from the outside. And humans have always tried to manipulate each other, but it's a big difference between external manipulations through the media, through propaganda, through advertising, and internal manipulation affecting the brain. And the difference is that when you manipulate the brain, you're actually changing the mental processing of the person. So the person will interpret this manipulation not as external to its body, but as internal. So you're essentially taking control of decision making. And this is not science fiction. We do this now in animal experiments routinely. The fourth neural right has to do with the possibility that neurotechnology will lead to mental and cognitive augmentation through the introduction of brain-computer interfaces that will connect our brains to external databases, to external artificial intelligence or supercomputers, or in fact to the entire internet of the world. So when that happens, and that will happen, humans will be mentally augmented. So we think that in principle this is good, but it should be regulated under the universal principle of justice to prevent a humanity with two types of people, people that are mentally augmented and people that are not. So this fourth neural right is fair access to mental and cognitive augmentation, to neural augmentation. And the final neural right is protection from algorithmic bias. And this is important because neurotechnology is associated with artificial intelligence, and the introduction of artificial intelligence algorithm inside our brain has the risks of bringing the potential bias that the algorithms have. And again, it's a big difference between receiving information from the outside that's biased or putting that information in your brain, because from that point on, you will interpret that as your own thinking. You will not look at it as a bias. You will look at it as this is the way things are. So, so these neural rights were published in a paper that the Morningside Group published in 2017 in the journal Nature. And since then, we've been advocating for neural rights in different parts of the world with different countries and different international organizations. And just to finish, I'll tell you that there's been successes in the Republic of Chile in South America, where the Senate and the Chamber of the Chilean Parliament have unanimously approved a constitutional amendment that makes cerebral integrity a basic human right. In Chile, in addition to this constitutional change, the Senate of the Republic has also approved a bill of law of neural protection that incorporates these 5 neural rights into the Chilean legislation. This bill is now being debated by the House, by the Chamber, and if the Chamber also approves it, which it is expected to, it will become the law. Besides Spain, I should mention, besides Chile, I should mention also Spain. In Spain, the government of Spain, the Secretary of State for Artificial Intelligence, has released a charter of digital rights, which covers all the rights of the entire digital world, but also covers neural rights. In fact, it incorporates these 5 neural rights into this digital rights charter. This charter is not legally binding, but it is expected to stimulate the generation of legislation in the Parliament of Spain. And finally, the United Nations has taken an interest in neural rights as well. We helped the Secretary General of the UN and his office organize a meeting this past July where this issue was studied, the confluence of neurotechnology and human rights. And if you read the report that the Secretary General published about a month ago, the Common Agenda for the UN for the next 6 years, you will see that there is one part of the Common Agenda where the Secretary General discusses human rights and the fact that the Universal Declaration is now outdated, particularly with respect to frontier issues. And the Secretary General Guterres mentions neurotechnology as one of these frontier issues that his office is going to tackle in the next 6 years of his mandate. And with this, I finish, and I'll be delighted to participate in the discussion and take questions. Thank you.
Thank you. Thank you very much, Rafael. It's very interesting what you're saying because there is probably, I believe that our digital rights are only the rights for shopping, for socializing, or for sharing information about, I don't know, in this social media and to interact with these communication applications that we have. But no, I mean, you refer to something in particular that I would like to with this to start our conversation and to make the first question. I mean, you said that in addition of this evolution of the legislative framework about all the laws that we have to work about, these also should include the development of ethics in digital rights. It is very important to adopt ethics in the developing of artificial intelligence, as you were referred. I don't know if you, Gus, can tell us what is your experience or the experience in your country about developing ethics and this legislation framework in intelligence and artificial intelligence.
I would say our experience in dealing with anything where you're trying to push against the march of language around innovation and new business opportunities and new market opportunities is that the excitement is too great to be stopped by the law. That's my concern, and we using the language and the institutions of the rule of law and human rights is admirable when we're trying to say that, okay, these institutions must come to understand new innovations. But when we need those institutions to actually push back, they're not there. They're not capable. They don't have the resources. They don't have the political resources. They don't have the will often to push back in the way that they need. And so instead, where we have to exist, and this is perhaps the virtue of the ethics debates, and the virtue of that Spanish example that Rafael referred to about stimulating legislation for years to come, that constant discussion and deliberation is what's needed. And so that it doesn't just fall ultimately into the letters of the law and into the hands of some regulator to enforce, because I guarantee you it won't. And what we also need, therefore, is to go straight to the innovators, go straight to the companies that are developing these systems and say, don't. Go straight to the buyers and say, you shall not. Because if we're relying on the traditional institutions that we've built up in the post-Second World War era, they're under such duress, they're not going to save us.
Thank you, Gus. Lorena, what's your experience in Ecuador about this legislative development ethics in order to have within the developing of artificial intelligence with legal framework and ethics? I'm sorry, we can't hear you, Lorena. I don't know if your mic is mute or no. I don't know if it's me or Daniel, can you hear Lorena? Daniel, ¿tú escuchas a Lorena? No te escuchamos. Creo que no nos... Claro. In order we solve the problems with Lorena, I will go with Katitza. Katitza, what's your experience about the developing of ethics in artificial intelligence? We can't hear either, Katitza. No te escuchamos,
Okay.
Katitza.
Now, okay.
There you
Voy a
go.
hablar en
Great.
español. ¿Puedo hablar en español? Sí. Yeah.
Perfect. Adelante.
En inglés. Okay. Inglés, español. Okay. Inglés. Okay. I prefer to focus on international human rights law and enforcement. I think that this discussion reminds me of the eternal discussion about regulation versus self-regulation. Ethics is another way of self-regulation, and we have been discussing this forever and ever. I think ethics are important, but are not the baseline. They were not put, as Gus said, a stop to access to our, like the previous speaker says, our brain data. I want access to my data to be privilege, like attorney-client privilege. I don't want the police to access my data, what I think, and I don't want them to access my emotional state. So I'm concerned about some of the principles. I haven't studied the principles to do a full analysis, but it's not only about integrity, it's also about maybe they shouldn't have access to that, or where are the limits to access to that. Will you share my mental data with third parties to produce other type of product? How that will work? We know that sensors, AR, VR sensors, will start collecting a lot of this type of data, and the egocentric collection of data, the collection, because the sensors of the headset will be looking at you, to your eyes and the movements, and in the future you may be able just to, instead of do like, you will do click with your eyes, and you will enter to something, use your eyes or even your brain to use the internet. It raises a lot of questions about intimacy, and more than, not only about integrity. Integrity is important, but it's not only about integrity. And I have those concerns about it. But just that.
Thank you, Katitza. Lorena, can you hear us right now? Can you? Tú sí nos escuchas, pero nosotros no te escuchamos. De acuerdo. No, seguimos sin escucharte, Lorena. Sé que tú sí nos escuchas, pero nosotros a ti no. Daniel, en lo que se soluciona esto, I'm going to go with Rafael. Rafael, with this that Katitza is saying about biometrics, about making or agree with clicks or with our eyes or face, what do you think are the principal challenges that we should be talking about biometrics?
Can you hear me? Can you hear me? Yes. So I'm not an expert in biometrics, but my opinion is that with biometrics, like with current technology that has already been deployed in a massive scale in the world, it may be too late to regulate, in the sense that it's already used, and it's always very difficult once things are out to reel them back. Almost impossible. There is this dilemma, the Colin Rich dilemma, that when a new technology is invented, you don't really know what is going to be good for or bad for, but it's very easy to regulate. At the same time, once the technology is developed and deployed throughout the world, you know perfectly well what is good for and what is bad for, but it's almost impossible to regulate. So I can imagine efforts, which I think are good, like the European GDPR trying to regulate data privacy, but there always come, this is like trying to patch a problem that we created. And it's with biometrics, it's I presume it's going to be something similar, but I'm not an expert really. That's why we concentrate on trying to provide guidelines, ethical guidelines and human rights guidelines for neurotechnology, because neurotechnology still hasn't hit the market in a big way. There's starting to be some products, but it's not yet quite familiar to people. So now it's a perfect time to prevent try to prevent future problems.
Thank you very much, Rafael. Gus, what's your opinion about this? Our principal challenges that should be beating all the countries about biometrics.
So, can you hear me? Please say you can hear me. Can you hear me? Yes, excellent. Okay. The direction of this conversation is exactly where we needed to be, because um, I'm old enough to have been around when biometrics were new, where they were like they were so new. They were where this neuroscience is now, and this all brings together everything that everybody said on this panel so far. When biometrics was new, it was unimaginable it would be everywhere. And then within 10 years, it was everywhere, but not because of the market just spreading it because Apple said it would be a great idea. It's because governments wanted it after 9/11, because they mandated it on the back of counterterrorism. They embedded it within our existing infrastructure of passports and ID systems. And then thousands of companies decided to innovate on that and try to rush to market on top of that. This is how these technologies get out there. And all of this happened when we already had a universal declaration. We already had the Fourth Amendment in the United States. We already had a data protection framework in Europe and most countries across the world. The law does not get in the way of when governments and companies decide that they want to innovate, that they want to deploy. And to stem that tide requires much more than the law, the courts. And I got to say, time and again, We need a study of the regulatory inaction around all of these things, and to say, what's to stop this from happening all over again about the technologies that Professor Yuste is going on about? Why do we think this time is going to be different? When we thought big data was going to be different 10 years ago, and it was not. AI right now, what's going to make it different? Will we be back at a conference in 10 years in Mexico saying, okay, well, we missed out on big data, we missed out on AI, we missed out on neuroprivacy, but we're going to get it right next time.
Thank you, Gus. What you're saying, I completely agree. I mean, what should we think that this is going to be different? Always, I mean, if law is always behind reality, I think with digital things, technology, and artificial intelligence, we are very, very, very back. So it's important to have this into consideration. Lorena, I think we have our audio back. And so I will make you this comment to know what do you think about these biometric matters that we are talking about, and also about the regulation of ethics artificial intelligence.
Ok, yo quiero contarles, no sé si ahora me escuchan. ¿Me escuchan?
Oh, can you hear me now?
No, Daniel,
Can you hear me
seguimos sin
now?
Lorena,
Hello?
can you say something?
Can you hear me?
Right now, right.
Everything you said is true. Okay, you can hear me now. We've been shown that the law, rather, it depends on the institutionality, and we see that in Ecuador. If we take the law to the protection of personal data, that goes back to 2008, and only in 2021 did we get a data protection law. That means that more than 17 years have gone by for us to be able to have the regulation. If at the same time we see what happens in other countries, I'm sorry, the sound is so terrible, I cannot interpret.
I'm sorry, Lorena. We're having problems, estamos volviendo a tener problemas. Daniel nos comenta incluso la persona que nos está haciendo favor de hacer la traducción simultánea que no puede escuchar bien a Lorena y por ello ella tampoco puede hacer la traducción de manera correcta. Lorena, a lo mejor está difícil o raro lo que te voy a pedir, pero si en el chat puedes escribir tu participación, a lo mejor yo puedo leerla y así podemos tener tu punto de vista. Si tú la puedes escribir aquí en el chat y entonces yo puedo irla leyendo, incluso la comento en inglés. What we're going to do, if you're okay with this, as we have problems with Lorena's mic, I think what we're going to do is she's going to write down the answer of the questions, and I will be translating and reading it to you so that we can make this little more efficient. So Lorena is saying that in Ecuador in 2008, they approved the right in the constitution to protect biometrics. But in 2021, I mean this year, this law in this law, they have already approved the right of regulation about biometrics. So they have them in their constitution, but the law, the secondary law, can't be implemented till today, right? She's saying also that this is a common problem in Latin America, that in some countries they make the constitutional modifications, but the secondary laws are delayed in make them applicable. So in Latin America, we can have these kind of laws, but the application or in the practice is a little more difficult. She's also saying that this practice of the single person, is not a reality. I mean, even though it's in the Constitution, it's not a reality because we have these implementation problems. So Lorena is saying that also this in Ecuador has a problem because you can't have the can be protected in an integrity. And she's saying something very interesting that can be our next question for everyone. What about the data transfer? I mean, we are, and of course, with this pandemic, we all get through the technology train, and we start to buy everything in internet, to have studies, to have our work on digital technologies. So, what do you think that transfer matters? There are some countries, European, that have this regulation, GDPR, about the transfer of international data. There are some other countries, United States, Latin America countries, Mexico, that we have to take into consideration all these international regulation about data transfer. I mean, these digital technologies are transforming the way of our rights are seen, such about freedom, expression, access to information, and obviously we need to have a protection of which steps should you think, or can you say that we have to have or to take into consideration, talking about privacy professionals. I mean, if you're the ones that are going to the implementation of all these issues about digital technologies transforming the way of seeing our rights, what would you suggest? And I will go first with Gus.
So the transfer of personal data across borders has been a continuing debate only because uh, a few large countries refuse to implement data protection law, to implement necessary safeguards. And when they do, those safeguards discriminate against non-residents. And that's what's broken. That's what's fundamentally broken. In the era of globalization, the fact that we couldn't fix that problem for the past 30 years is just embarrassing. And we all know it's about America. But we also know the future is not about America necessarily in the same way. It's about China as well. And the transported data flow problem is going to become even more confusing as we've uncovered with the EU-US fake fight that's been going on for 20 odd years and then it got a little bit crazier when there's the concern that American intelligence agencies might have access to data of non-Americans held in the United States and Europe European intelligence agencies had vast access with weak regulation as well. And we went to court to try to fix that, and that's still like pushing the stone up the hill. The problem isn't just the transborder problem. The problem is weak law and protection domestically and internationally, yet by the very same governments who've been pushing globalization on us for the past 30 years. I don't get how we've fallen between the cracks on this for 30 years and we still haven't fixed it.
Thank you. Thank you very much, Gus. I will go with Rafael. Rafael, what do you think about this cross-border transfer international of information, and also about all these challenges as privacy professionals to regulate and to protect about our information from violations?
The problem with technology and privacy, it's so enormous that we need to approach all potential solutions that we can. So I heard comments about self-regulation of the industry, but that, as we can see with the internet and with social media, that's not going to happen unless there is a serious reason for the industry to take that as their duty. So we're a little bit more optimistic with respect of the power of international organizations such as the UN and other organizations. And I would put an example, for example, what happened with the regulation of the atomic energy, with the Committee for the Disappeared, the Convention Against Torture, the regulation of biological and chemical weapons. So these are all critically important problems that humanity has faced in the last 100 years, where the UN in particular has played a major role in at least regulating and controlling the use of these types of technologies. So with the case of data privacy, given that there are many players like China that are not part of the same discussion that we're having in the West, I think it's particularly appropriate to use the UN and international organizations as the tool. So not everyone in the world agrees with human rights. Only 130 countries have signed the convention. And as you know, there are many different human rights, and there are different countries that are at odds with some of them, including China. But at the same time, we should not diminish the power of human rights approach and the power of a convention, for example, led by the UN to tackle problems. So imagine there was a convention to protect privacy, both data privacy and mental privacy, and that could lead to a type of recommendations that different countries could violate, but they would be subjected to sanctions, just like they are if they violate the nuclear weapons or nuclear atomic energy convention. So that's just one way to think about how to solve the problem. But I would approach both from the bottom up, trying to get the industry to regulate itself using all kinds of ideas that we could apply to the industry, but at the same time just come from the top down, from the UN and from the government. You don't need the UN. Look at what happened in Chile. So if the parliament of a country is decisive enough and brave enough, they can also regulate it by themselves.
Thank you very much, Rafael. Katitza, I will go with you about the biometrics and this interaction with the protection of our rights and talking about technologies. Just let me say to our public, if you have in the audience, if we have any questions, if you have any questions, please let us know, because it's important that you can have this interaction with our great panelists and to have their point of view from different parts of the world. So please don't hesitate. If you have any questions, let us know so that we can ask those questions to our panelists. Thank you. Katitza, please. We can hear you, Katitza. I think you're mute.
Okay, gracias. There is one comment I would like to make in the context of biometrics, and more in particular in the context of facial recognition. First, technology has the power to improve our lives, but it's also has been used to intrude in our privacy and freedom of expression rights. Every time the technology is used by the government, we should raise difficult questions like, should it be adopted at all? What are the benefits and the costs? And if it's adopted, who will be targeted? Will it actually make us safer? A democratic society requires informed public. But unfortunately, when it comes to biometrics and use of in other surveillance technologies, there are little information about what the governments are acquiring and, and whether we can engage in the process. That's why I believe that the public should always be notified and have the opportunity to make public comments anytime a relevant government agency wants to acquire a new form of surveillance technology for biometrics, facial recognition, that the agency requesting the technology provides, and that it should be also know that you should have a policy and report outlining if the technology would have a disproportionate impact in marginalized segments of the community. But there is one form of spy tech that we firmly believe cannot be responsible regulated. EF is calling for the end of the government use of we call it face surveillance. When I said face surveillance, I am referring to face recognition systems being used by government agencies to identify or verify the identity of a person using their face. This system can be used to identify people in pictures, videos, or in real time. As you have likely heard, face recognition is really bad at recognizing women, young people, African Americans, and other ethnic minorities, always misidentifying them. But even if the technology didn't have the concerning inaccuracies that it does for people that are not young adults, while males, it's used by law enforcement. The use by law enforcement will always threaten our essential freedoms. Its use is surveyed, well documented. It's recommended the racially biased police practices in this context. Also, the law enforcement databases, like the MacShot databases, unjustifiably include a disproportionate number of Black persons, brown persons, immigrants, and trans women, implicating people from crimes that they did not commit and shifting the burden onto innocent people to show that they are not the person whose image the system has matched them with. One of the things that scares me the most is about the number of databases and the fact that half of us likely have our image in one of those. And they are not properly secure. Keep in mind, if there is a security breach, I can change my driver license, I can change my passport, but the people affected by breaches of face surveillance databases can change their faces. Some advocates for face surveillance would argue that there is no right to privacy in public spaces. We disagree. We don't give up that right simply by walking outside. Also, face recognition or fake surveillance chill freedom of expression, which is really, especially in public spaces. The right to freedom of expression protects the right to confidentiality when engaging in expressive activities such as protest. Anonymous speech, private conversations, confidential receipt of unpopular ideas, gathering news from undisclosed sources, all are expressive associations. All of these expressive activities depend on freedom from surveillance because many participants fear retaliation from police, employers, or neighbors. And we see this as a trend. Yet in the past 2 years, law enforcement agencies in the United States have been using face recognition to identify, for instance, Black Lives Matter protesters. We have seen similar use of the technology to target activists in India and Colombia. And so this is the reason why we are asking to ban such technology by the government. Thank you.
Thanks to you. Very interesting what you were saying, what you were introducing about this face recognition. I think it's very important to have this into consideration. And I will go with Lorena. I don't know if Lorena, if you can say something just to know if our audio is good. If not, I will read. I will read what you write down.
So, talking about rights, about personal data protection, all of this then can go to biometrics, but that's where we don't agree. In conceptualizing a human right, there are two models in the world. One, which is the highest standard, which puts the person at the center. And the other one, that simply visualizes a person from the point of view of privacy. So only certain things you can complain about. That reactive model is the one operating. I'm sorry, but no, her voice is coming and going. The balance overall has to be on the other side. It is the company, the entity, or the state that has to demonstrate that what they are doing does not affect the communities. And this is putting the person at the center. If we don't do that, we continue to prolong the problem, whether through artificial intelligence or by other means. That change has to come about through an international agreement that most likely might be approved by about several countries. But at least it will set an international standard, and that this will be considered as a new digital generation. If we do not achieve that, then what Gus said will happen. Another 30 years will go by. Well, this is still being addressed as a local regulatory problem of self-regulation, of ethics, or simply a business matter.
Thank you. Thank you very much, Lorena. And thanks to the translator. Thank you. Thank you so much. Also, Lorena, write down here at the chat that the examples are very important about regulation, about security information regulation. and the recognition of these fundamental rights about human dignity. So it's very important to have um, or to recognize that we have no equity in the world about the models that recognize the data protection and other ones that are only limited to the security information, talking about a single person. So talking just about this, about discrimination and this regulation, let me now go to the other side of the coin. If we are singular persons, how could we know if our digital rights are being respected? I mean, if I am a common, a regular person, and I am interested to know if my digital rights are being respected, what should I do? And I will start with Rafael, if it's okay for you. Because we're just talking about the regulations and the companies and entities, but talking about people, about the individuals,
Yeah,
how could they
yeah, yeah,
know?
yeah,
I
yeah.
mean, it's a different. How could they know if their digital rights are being respected?
So the citizens and the consumers are going to have to just trust the public institutions the same way that when they buy an aspirin, they have to trust that it's not going to kill the person. So, and the reason that happens with pharmaceuticals and medical devices is because there is a national organization, which could be an Instituto de Salud Pública or the FDA in the US, or depending on which country has a different uh, structure. And these organizations are watchdogs for the public, and they only allow certain things to be sold, and they control the side effects and the negative effects of these products. No, so we envision, at least for I'm speaking about neurotechnology, so not about all of the digital technology. So I'm not an expert in other digital technologies, but in neurotechnology, we envision. I think this is the solution actually that has been that's put into the law in Chile, that the National Institute of Public Health will have a record of all the devices that are that want to be sold in Chile, and then they will study the application of the devices and approve them or not. And the companies behind the devices will be legally responsible for any problem or any misuse of the devices. So let's say that you use a device to record brain activity, and that data goes somewhere else where it shouldn't be going. So that company is legally responsible, just like the person that sells the drug that has side effects is legally responsible for those side effects. And this is something that doesn't happen in the tech industry. So we want to import the medical model to the digital technologies, at least to neurotechnology, so that I think the medical industry has a regulation that goes back now 2,000 years with the Hippocratic Oath. There's a lot of ethics and guidelines that prevent disasters, and this has also been learned in history through some disasters that have happened. So we've learned from our mistakes. But I think with the digital technologies, particularly with neurotechnology, we could actually, instead of waiting for a disaster to happen and then come up with a potential regulation, we can be a little bit more proactive and prevent these things from happening. So our solution would be to essentially create new organisms at the state level that could be equivalent to the FDA, but applying for digital technologies in the case of the US, or equivalent to Instituto de Salud Pública in different countries in Latin America or the Spanish world. And they will be endowed, of course, funded to do this, endowed with the responsibility to watch for the public and approve or disapprove these devices, and also regulate and pursue potential liabilities if there are side effects.
Thank you. Thank you very much, Rafael. This is very interesting what you were saying about applying with an analogy about all these health solutions to technological matters. It's very interesting. What I have learned, I'm a lawyer and I work with some engineers at the law firm talking about security information, and always said to me, try to figure out something from the physical world to the digital one so you can solve the problem. So these that you put in the table, it's very interesting because that's a very, very good idea. How can we solve these matters? I don't know if Gus, Katitza, do you have any, Lorena, any comments about these things? I go first with Gus. Please, Gus, go ahead.
I love the idea of taking the medical device regulation and applying it to other types of technologies that are being promoted. The catch, and it's an unfortunate catch, is that the tech industry is expert at navigating around that. And so I've been looking, for instance, at emotion recognition. And it's similar to a lot of the technology you're talking about, Professor Yuste, but it's done with data and remotely. And it has no, like, even though they claim accuracy, it is inaccurate. It's based on flawed science. It's kind of like when the earlier studies of facial recognition and discerning moods or attitudes or even political opinions and sexual orientation. It's all this faux science, and it doesn't stop them from selling. It doesn't stop it from being bought. And so if we force them to be honest and to be clear about error rates and to be clear about the sources of the data and the scientific validity of their claims, then this would be such a much more advanced debate. Rather, what we get is companies pretending that they're innovating, selling something they claim is perfect when it's far from it. And when we finally catch up, they've actually made it just a little bit better to say, oh, but it's better now. It no longer discriminates against people as badly as it once did. It no longer fails as often as it once did. And there's about 10 times the number of companies out there building and innovating, and then you have a market. And this is the innovation we're seeing. We're not seeing flying cars, we're seeing facial recognition. Isn't that disappointing? This isn't the future we were promised.
Thank you, Gus. That's correct. I mean, that's really true. And these biometric issues, I mean, they are not. They're not 100% secure. I mean, if I get a flu, probably my eyes are having another look like, or my voice probably. So this is very, very, very interesting. Katitza, I don't know if you have any comments about these things coming around. How can I know if my digital rights are affected? Please go ahead.
There have been so many ideas which I want to react. I'm a little concerned about introducing the concept of neural rights without having a broader discussion on how the technology works and within which context these neural rights initiatives start. So what I heard, the initiative is in the context of what is called augmented reality or virtual reality, which is collecting not only biometric data or the physiological data, but also not only our voluntary actions, but also behavioral and anatomical data that we disclose involuntarily. Like if how many times I close my eyes, I cannot. Sometimes I control when I close my eyes, sometimes I don't, and that will disclose. For instance, if I'm looking at a person or a thing for a long period of time, and it's like a Facebook like button on steroids when we are talking about this technology. So I think it's very important to put a pause to understand what is these neural rights and what should be the limits to not only our rights but the limits that should exist in the processing of this type of data, if any. This is emerging technology, so this needs a lot of discussion on the topic. We should discuss not only what we can predict or to what extent, as the professor just, is that possible, but if we should make those, but we should also discuss about whether we should do some of these correlations at all. The EU is working on the AI regulation, which is very related to this. So I wonder, how the EU AI regulation is related to this neural rights initiative, whether we need something more broader or something more targeted. And that's like a very broad topic that requires a lot of discussion. And with a little time, I'm sorry, we will be able to go deeper on that. But when it comes to the actual question about how do I know that my rights have been respected, this is a very tricky question. For instance, one of the obligations of companies we want companies to publish a human rights impact assessment or data protection impact assessments. Those documents are not public, so there is no way to know whether the new initiative, like the new innovation, will comply with such standards. We need more participation in relation to data processing, data protection impact assessments. For instance, more involvement in processes that require with risk data processing, with higher risk data processing of data. Article 13 of the GPR is kind of good, but it's weaker in consulting with third parties, organizations of users. Companies should do more and publish some of these human rights impact assessments. They should make it public. What else? Well, I think that it's hard to know if there is no transparency. We need more enforcement and more details in the solutions of enforcements. When it comes to analyzing companies, sometimes the resolutions are not as deep, depending on the country, analyzing how, for instance, certain practices are discriminatory. What else? I think that it's more like more transparency, more enforcement, more involvement of civil society on risk assessments, on human rights impact assessment, on when they use AI and this type of inferences, and also have a discussion of whether some correlation should we make at all or not, whether we should do it or not at all. This is very, very new process, and I would like to call on DPAs to get into understanding new technology and how that will impact the future of the processing of our personal data. I think this is a new fight, all related to augmented reality and virtual reality, whether you call it neural rights or biometrics or psychological inferences on correlations of our voluntary and involuntary disclosure of data. That's all.
Thank you, Katitza. Lorena, as we have sound backs.
Bueno, yo empecé comentándole que
Well, I started by saying that there's a need of building a culture of protection. We started talking about women's equality, a process to raise awareness and also of education and training in which all the stakeholders contribute from their own fields to create egalitarian societies. We can also work with data protection with that focus. We have to raise awareness. We have to educate boys, girls, and adolescents, train professionals who are specialized because we don't have enough. Proof of this is that there are not enough NGOs to protect digital rights. There are no professionals specialized in security or cybersecurity. And finally, the actions of the company, the academia, and the organizations that have to be part of this process to train society as a whole. If we don't have this, there won't be awareness that I have a right, and even less I can complain if something is not okay for me. And the thing is, if we place this responsibility only on authorities, we are losing our freedoms because we are not exercising them. Consequently, we need a comprehensive work. It's not easy, but this we can do something and replicate this. Thank you.
Thank you. Thanks to you. Thanks to you, Lorena. It's very important what you're saying. I mean, we need to re-educate. We need to go back to basics, right? To put us with our foot on the ground and to establish what is important, the principles, and to establish. I mean, whatever is not to be negotiated, right? And this led me go to our final part and another player in this digital rights game, that is the authorities. What about governments? I mean, we were talking about entities, corporations, individuals protecting their digital rights. But what about governments? There are some governments that want, obviously, to use this information for another purposes, or also to have much more information that the one is needed. I don't remember if it was Rafael who talked about the case in China, that China has some specifications about biometrics and the use of these biometrics matter. So what's the government role in all this? I mean, we need to have a balance in between the protection of our privacy, our personal information, all governments to be respectful with these, but they have an A, no, here saying national security, or I will need to have your information to do A, B, or C. So, what's your opinion about the role of governments in protecting our digital rights? I will start with Katitza, if it's okay for you.
The role of the data protection authorities, great. I think they need to be independent and impartial, and they should have their laws, enforcement powers, and a budget. I would like to see them even more engaged on their duties to protect data protection. There are a lot of negotiations, as I mentioned in the morning, on law enforcement, data protection in the context of law enforcement. Mexico does have one law for the protection of personal data in the context of law enforcement. And we know also that some countries has exempt police from their data protection law, although not totally, depend on the country. And we have the United States, who does not protect the privacy of foreigners. But I think DPA should get engaged in these discussions in multilateral agreements. So the standards that you already have that are strong are replicated or they don't end up being undermined by these international agreements. I have concern. The UN is not white and black. Like, we brought the necessary and proportionate principles, 13 principles, to explain how international human rights law applies in the context of communication surveillance. We were not rewriting international human rights law. We were just explaining that. And we did that by mapping all the court cases from human rights courts, by mapping the opinions of the Human Rights Committee, by mapping the opinions of the special rapporteurs, and comments from the Human Rights Council, among others, to justify this set of 13 principles. But we were not trying to rewrite. The trend that I'm seeing right now at the international level is try to use the need to pass international human rights law or safeguards to undermine what we already have in many countries. It's like a race to the bottom of privacy protections. A lower, like harmonize the safeguards to the lowest common denominator. And we see that in the coming UN Treaty on Cybercrime. We are seeing that in the second additional protocol to the Budapest Convention. Well, we haven't seen the UN because that's starting in January, I'm saying, but I think something like that will come up. The second additional protocol to the Budapest Convention, and we see that in the OECD, the set of principles that were discussed that are under evaluation about safeguards in the context of law enforcement access to data. So I think that that's my call for the DPAs to get engaged in these discussions when these international treaties are discussed in Congress. Please get engaged too. It's about law enforcement, but it's about data protection in the context of the police, collection of and use of personal data, and try to ensure that your standards don't get undermined in such processes. Yes, that.
Thank you. Gus, what's your opinion in the authority matters?
Katitza said everything that needed to be said about data protection authorities. And I would just repeat again, like, we didn't fight for years to get laws around the world for data protection authorities to be conservative. You know, it's just embarrassing that all that effort goes into regulators who are just so confined and so timid. And let me just say, surveillance technology, whether it's neurotechnology, whether it's facial recognition, whether it's AI, it doesn't fall out of the sky and end up somewhere. It doesn't fall out from the laboratory and end up at a border. Governments are the ones who create the markets for these companies to sell at scale. And so today, for instance, in Europe, we launched a complaint, not to a privacy regulator, because the regulator would be useless. We filed a complaint with the EU Ombudsman because we are seeing the spread of surveillance technology across the world in countries that can't afford surveillance technology. How are they affording it? They're getting EU money. EU money for the externalization of borders, EU money because the EU is terrified of migrants. They're sending money and capability and surveillance tech to other governments who don't have safeguards, who don't have Lorena's most recent points were just fantastic about the richness of civil society and national debate. And then all of a sudden, that's being undermined by EU, or it could be Chinese money, or it's American money going around sponsoring the spread of surveillance technology. And so governments create the markets, they create the opportunities, and they even fund the deployment of these things. And yet all we can do is like look to a data protection authority who's timid, or look to the courts who say, well, it's not our jurisdiction, and hope that the UN will step up and do something. And it doesn't work.
Thank you.
I
Thank
wanted
you,
to end on a
Gus.
more positive note.
It's okay. Thank you. Rafael, what's your opinion about these authorities?
Yeah, actually, I wanted to first answer to Katitza. There's a lot of information on neural rights and neurotechnology. I encourage you to look at this website that I put on the chat, and also look at the papers that have been published and the documents generated by the international organizations such as UNESCO, OECD, and more recently the declaration of the Secretary General of the UN. And this is not AI. This is completely different from artificial intelligence. The European Artificial Intelligence documents have nothing to do with neurotechnology. In fact, we were at Brussels 2 years ago talking to two of the offices of the commissioners for technology and health, and we've also talked to the group that generated the GDPR, and they are thinking about neurotechnology, but they haven't really incorporated that into their work stream. So this is a new challenge, and again, in the spirit of my comments earlier, I think it's our responsibility to be alert and do something about it before it's too late, like it happened with all the other technologies. No? And in terms of your question, Nuhad, on the role of states, I think the case of Chile proves that they can be a critical partner in this debate, and that individual states acting by themselves without the support of the rest of the world can write law and do history. A lot of the beautiful thing that's going on in Chile is that these concepts such as neurotechnology, brain-computer interfaces, mental privacy, all these things are acquiring a legal entity for the first time in history. So this is something that it's very encouraging. And I think my spirit here is goes back to the old adagio of think globally, act locally. So we can have all these global issues in mind, like privacy, mental augmentation, dignity, but and we should push at the global level. But that doesn't mean that we cannot do in our own countries, in our own structure, in our own organization. We can move the needle there too. And sometimes these things are inspiring. These local efforts inspire other efforts. Let me just give you one example. The Chilean case has inspired the Organization of American States to pass a unanimous resolution to consider neurotechnology as a top priority in human rights for the next summit. So there you go. So now Chile has brought in the rest of the continent, including the US, which is part of the Organization of American States. So this is going to get debated in the next summit of the OAS. No? So I think this is just an example how we can bring in the countries and through advocacy and hard work and coalition building, we can change things.
Thank you very much, Rafael. Really, really interesting. Lorena, what do you think about the role of authorities?
I hope you can hear me. Perfect. Well, I think regarding data protection and authorities, we've said everything. I could only say that we need to establish a world body that organizes them, harmonizes them, and allows them to work jointly, especially because they have to learn to... I'm sorry, her sound is cutting. So if they can go after what is been taking place in different countries to avoid personal data being cut by someone. Likewise, I think it is important to go or to include international bodies, Inter-American Courts of Human Rights, the European Court of Human Rights, etc. Because only if we have an international jurisprudence that recognizes this as a fundamental right, we will have the legal scaffolding to have a fundamental law for human rights. We are not using the tools to take a leap. and this is because we lack internal organization, that is civil society organizations and the academia.
Thank you, Lorena, very much. And I will start with you as a final conclusions, final message that you, each and every one of you, want to say, to tell to our audience. Any conclusions, any practical advices, or any final comment. And I will start with you, Lorena Naranjo. And thank you very much for your patience in this technical problem. Lorena.
I think this renews our commitment. All of us, from each one of our fields, the academia, civil society, have to work so that this becomes a fundamental right, and digital rights are enforced at the court levels, at the legal level, at the level of international agreements. And that should be in the debate, so that, in fact, AI and new rights are within this protection framework that, well, we are the ones that should be protected and not technology. It's not the use of technology as an end, but rather the end is the development and the protection of human beings. Thank you.
Thank you very much, Lorena. Gus, your final statement, final positions or conclusions about the panel.
I want to end on a positive note because I feel like I'm just saying all these bad things are going on in the world. And I think the reality is we've never had more resources, like more friends around us. We've never had a more informed society and a more sophisticated discourse and eager debates. And so we're in a very good place. We're in a very good place to do this better. My hesitancy is that we're in a good place, and yet the institutions that we need have never been more frail. The courts, the law, human rights as a concept, human rights institutions, and unfortunately, much to my disappointment, data protection authorities. This is a moment where we can say, actually, everything's on our side. People are on our side. Debates are on our side. The movies are on our side. Innovators are increasingly on our side. And so, can we make the most of this moment and do something positive? And I love the way Lorena and Rafael and Katitza keep on coming back to not just this notion of human rights or even constitutional rights and international bodies as these august institutions, but what we keep on coming back to are issues of dignity, autonomy, and the regulation of power. And if we can speak those languages, we'll reach across many more people and actually affect real change.
Thank you very much, Gus. Rafael, your final statement and conclusions, please.
Yes, can you hear me now? Yes, great. I think maybe my final statement is to give our audience the message that technology is good, that this is fantastic what's going on with technology, with digital technologies and with neurotechnologies. No? Technologies are the way in which humans become a better species, and they lead progress. And this started with the fire, and now it's digital technologies and neuroscience. No? So we may have given some people the impression that they should be worried or they should be scared of the future, but it's the opposite. I think the future should continue. Technology should lead the future. But what we need to do is to make this future responsibly. No? Technologies are neutral and they could be used for good and for bad. So the person that invented the fire was able to make his group of people survive the winter in their cave, but the same instrument can be used to burn the cave of the group of people next door. So technologies can be used for good and for bad, and we just have to put the guardrails in so that this happens, and this can lead humanity to a better future. In our minds, these guardrails are human rights. These are actually wonderful tools that have not been used enough. And as I said earlier, they are agreed upon the majority of the inhabitants of the earth. Not everyone, but most of us. So I think this is the obvious tool to put the guardrails into the technology so that they can lead us into a brighter future. And I honestly think this will be a renaissance. The application, particularly of neurotechnology, to humanity will lead to understand who we are, understand the role of our behavior, and improve the medicine, and at the same time lead to a better society, a fair society, and one with there's less conflict and ideally less wars as well. So it may sound very optimistic, but I honestly believe that that's the future that we can reach with this technology. Thank you.
Thanks to you. Thank you very much, Rafael. Katitza, your final statement and conclusions, please.
Very, very quick. First, I want to thank you for the kind invitation and be able to see everyone online. Wish we were together and having some mezcal after the event. But just want to say that we need a lot of, I think, fairness. It's about, I agree with Gus, it's about human dignity, but also justice and democratic values. I think it's also about fairness and transparency. And I think that those are the things that we should be highlighting more in discussions. I just want to do a final call on the DPA and the Global Privacy Assembly if they can issue a resolution on the topic of on data protection in the context of law enforcement. Latin America doesn't have all the laws or doesn't have necessarily strong laws in that context. While many has adopted the GDPR and many have implemented the GDPR in like Barbados or Brazil and the new law in Ecuador, we still have much work to do. We need to do much work in the context of the police use and collection of our personal data. And so I'm calling them that in the GPA to be able to do a resolution in the context of cross-border policing, and that will support higher privacy and data protection standards. Thank you very much for the kind invitation, and looking forward to keep the conversation offline too.
Thank you. Thank you very much to you all first to think outside the box, to make this panel different, to interact with each other, and to solve practical problems and problems from our day-to-day privacy professionals that are listening, that are watching us. Thank you very much to Deinai to be the host of the GPA, and thank you very much to all the organizers for inviting, and I was really to moderate these excellent panelists. Thank you so much, and well, see you soon.